Okay, now, you're good now.
Hi, everybody. This is our last session for today, and we're honored again. Joanne Fawzy from Triage Cancer. She's a founder of Triage Cancer, her and her sister, and she's also a writer and an attorney. And she's going to help us understanding finances and estate planning today. And so let's give her a warm welcome.
You don't need me to use the microphone, do you? No? Yeah, maybe?
Maybe.
No.
Talk just a little louder.
Oh. So, talking about estate planning is actually really difficult because no one, if I thought health insurance was like walking on broken glass, estate planning is not a topic that people like to talk about anymore than health insurance. But when we say the words estate planning, it's really an umbrella term to talk about all the potential documents that you might need to prepare for all the possibilities of things that could happen. And it's important for everybody. Every adult should have an estate plan. A lot of people think that if you are not Mark Zuckerberg or you haven't amassed a great deal of wealth, that you don't need to plan your estate, but really everybody needs to think through some of these decisions because they apply to everybody. Because estate planning includes things like documenting your wishes. There are ways to protect your loved ones, your family, your friends, to make some financial decisions, and ultimately to create some peace of mind for yourself to make sure that your wishes are actually complied with, but also to alleviate some of the decisions that your family members might need to make if you haven't thought through some of these decisions. So these are some basic questions that we ask everyone to think about when they're thinking about planning their estate. So what do you want to have happen to the things that you own when you die? Are there people who you're responsible for? Do you have minor children? Are there people who you want to make sure are taken care of? Do you know who you'd want to make decisions for you if you're unable to make decisions for yourself? So all of those things include estate planning. So the first step of estate planning is figuring out, what do you actually own? That's not such an obvious question sometimes, depending on the state that you live in and if you are married. So you have to think about what are the physical things that you own, and that could be real property, it could be homes, it could be a piece of artwork, maybe it's a piano that's been in your family for a while. What are all of those things that not only you own, but that you care about? And then think about the things that aren't physical. And this, I think, has become more and more complicated in the world of being online. So, do you have bank accounts or retirement accounts or a life insurance policy? Do you have music that's online? So people aren't thinking about things that they own that are actually accessible online. And then you have to think about what are they actually worth. So if they're things like a piece of art that has been in your family for a long time, do you need to get it appraised so you understand what the value is in the context of planning your estate? And then you have to think about how you actually own it. So is it joint ownership? Like, do you own a house with a spouse? Is it a life insurance policy where you've actually designated a beneficiary on the life insurance policy already? So you need to think about how you actually own those things. There are also things that you own by contract. So do you have a car lease? That's actually something that you own and you have a responsibility for, but it's not full ownership because it's a lease. And then you need to think about what are the documents that you need to actually plan your estate. And for everyone, the documents you choose are going to be a little bit different based on your preferences and how you feel like you need to make those decisions. So I'm going to talk through some of these key documents and explain how they're different. So the first is a power of attorney for financial affairs. And this allows you to appoint someone to make financial decisions for you while you're alive, in case you aren't able to make financial decisions for yourself, or you're not in a position to do certain things. So think, for example, if you are in the hospital and you need to pay your rent, but you don't have your checkbook, who is designated to be able to go to the bank and actually transfer that money to pay your rent, for example. So it could be some pretty basic things to think about. Now, there's powers of attorney for financial affairs that are standing, so they go into effect the moment you sign that document. So at that moment, that person you're appointing can make decisions for you. And then there's something called a springing power of attorney, and this is actually more common, so that if there becomes a moment where you aren't able to make decisions for yourself, that someone can make them for you. So it springs into effect at the moment that you aren't able to make decisions for yourself anymore. This is not a replacement for a will or a trust, because this power ends when you pass away. That's where a will or a trust kicks in. Now, the downside to not making some of these decisions and putting these things in writing is that if you don't make these decisions for yourself, then ultimately a judge might be the one making decisions for yourself. So if you aren't able to make those decisions financially, and you haven't appointed someone to help you out with that, then a judge might be making those decisions. So ultimately this is about a little bit of power and control over what you want to have happen and to be able to make those decisions and putting it in writing. Now, a will is a legal document that allows you to make lots of decisions related to your property and your assets, but it's also a place where if you have minor children, you can appoint guardians for your children if something were to happen to you. Things you don't include in your will include life insurance policies or retirement accounts, because those documents, you're actually choosing someone in those documents for that money to go to in the event that you pass away. So they're outside of your will. They're separate. And there are different types of wills. So some states actually allow holographic wills, which mean handwritten wills. And actually one of my favorite estate planning cases in law school was someone who wrote their will on a suitcase. And it was valid because it was handwritten and it was signed by that person. We don't recommend this. This isn't a good way to approach estate planning, but in an emergency, there are some states that allow holographic wills. There are states like California which actually have statutory will forms. So written into the law, there's a form that you can fill out. And if you have a simple estate, it's actually a really easy way to write down some key things that you want to have happen. And then certainly there are lots of online services, things like LegalZoom, where they'll help you actually fill out simple wills. And then if you have a more complicated estate, you actually might want to sit down with an estate planning attorney, because sometimes there are also tax implications related to estate planning that an estate planning attorney is going to be more familiar with, or have someone to refer you to that deals with accounting and tax issues. So depending on where you live is going to depend on what options you have in terms of completing a will. And on our website at triagecancer.org, you can find the information that's state specific about what the rules are in your state, and resources to help you find legal assistance. So generally speaking, you have to actually be over the age of 18 to create a will and be of sound mind, meaning that you're actually capable of making those decisions for yourself. It usually needs to be in writing, signed and dated by you, and then in most cases it also has to be witnessed, typically by 2 other people who are uninterested, which means they don't benefit from your will. So 2 people who are unrelated to what's going to happen to your will. You are able to change your will at any time. You do that through a codicil, and it's basically just an additional document that describes the changes to your will, but it has to be executed in the same way that your will was. So don't go and just like cross out things from your will, because that won't be valid. So you actually have to execute it the same way that your will was. And I mentioned that if you don't write some of these things down and make these decisions for yourself, that ultimately someone else might be doing that for you, even a judge. But there's also a lot of consequences financially to not having a will. Your estate will have to go through probate, and that's expensive. You have to pay to enter into probate, and then whoever is the executor of your will is going to have to deal with that process. So that's why it's important to actually think through some of these decisions and write them down. So we have a lot of tools. I brought some of the checklists that we have available related to estate planning. They're on the table in the back. But this is just a quick checklist of things to think about when drafting a will. Now, if you do have a more complicated estate where you have more assets or you have family members where you want to benefit maybe now from your estate, then you might want to consider a trust. And I'm not going to go into the details of a trust because it's something that you typically don't do on your own. You need to go to an estate planning attorney to get help creating a trust so that it's valid in your state. But the same principles apply. It just creates an entity. So when you have a trust, you're basically giving your assets and your property to the trust. You can have control of those assets and property until you pass away, but you're putting it in the ownership of the trust. So there are also different types of trusts. In some cases, special needs trusts come up in the cancer community quite a bit, where if you want to be able to care for a young adult with cancer, for example, but you don't want them to not be eligible for government benefits, you can put resources into that trust that will benefit them without knocking their income level up, which kicks them off of eligibility for government benefits. So there's lots of different ways to be able to use trusts and estate planning documents. But I do want to mention HIPAA forms, and I know this came up earlier about the challenges related to HIPAA. So HIPAA stands for the Health Insurance Portability and Accountability Act. That was passed in 1996, and it has lots of things in it, including privacy protections for your medical information. And so if you want other people to be able to have access to your medical information, so if you are an adult, but for example, you want your parents to be able to have access to your medical information, you need to sign a HIPAA release form, which gives your parents the ability to get access to your medical information from your healthcare providers. Otherwise, your healthcare providers might say, I can't release that information to you because I don't have a HIPAA form. So this is something that you can ask your healthcare team for, and they'll provide it to you. Now, when it comes to
Is it one per doctor or just one form that would work for all providers?
It can be one form that works for all providers. In that case, I would say make a copy of it and keep it for yourself so that you could hand it to any provider.
So it doesn't have to be specifically to doctor so-and-so and then another one's to doctor so-and-so?
No. If it's a broad HIPAA release form, you're giving someone permission to get access to all of your medical information. So the provider doesn't necessarily matter. Some providers might ask you to complete another one for them specifically so they can keep on file, and that doesn't hurt. But if that's something you're concerned about, then having one that you keep with you is useful. So when talking about medical information and making decisions about who might make medical decisions for you if you weren't able to make them for yourselves, that's where advanced healthcare directives come into play. This is also a form that's legally binding that you have to complete and sign and date. You can change it at any time. It's fully revocable. Some states actually have online registries where you can upload your form to that online registry so that any provider can get access to it in your state. But there are different parts to an advanced healthcare directive. And sometimes advanced healthcare directives are called living wills, but living wills are really just one part of a directive. So a living will basically says, these are all the things that I want to have happen to me if I weren't able to make decisions for myself. You can lay out all of the potential things that could happen and make decisions around them. So, for example, I know that if I weren't able to, if I have no brain function, for example, then I wouldn't want extenuating measures being taken for me, because that's important to me. Those are the types of decisions that you can lay out in a living will. A lot of people find it really hard to do this because then you have to think about all the potential things that could happen and then describe them. So sometimes people don't want to do this, and instead they just create a power of attorney for healthcare, which is different than the power of attorney for financial affairs. This is specifically about the medical decisions. And you're basically just appointing someone to be able to make those decisions for you. You can have part 1 and part 2 or you could just have part 1, or you could just have part 2. So my husband would probably be the worst person for me to appoint as my healthcare proxy. He's not good at making those types of decisions, and he would probably disagree with me because his opinion is, you do whatever you can to keep me alive, whereas that's not my opinion. So if I want my opinion and my wishes to be taken into consideration, I have to find someone else. I have to ask my sister to make that hard decision for me, not him. So thinking about who you're actually going to appoint for a healthcare proxy is important because you want to pick someone who understands what your wishes are and are actually going to comply with them. Then there's organ donation. The hard part about making these decisions is you kind of really have to think through these things about and think through what's most important to you and then document them. Interestingly enough, my husband told me I couldn't donate my organs. And I said, well, you don't actually get to choose. I get to choose. And I'm an organ donor, so guess what, you're gonna have to comply. And he was like, okay, fine, but you can't donate your eyes. But why? And he just felt very strongly about that. So he couldn't explain it. It was just a reaction and just a feeling that he had. So everything about this is about your personal feelings and making sure that you're documenting them so that what you want to have happen, happens.
I just have a quick question. So, our particular circumstance with the ocular melanoma, I mean, I've been reading just lately that they won't let us donate our organs because it goes through the bloodstream. Is that what
I think
everyone
that's
else is
true.
getting?
Yeah, we
Because
can't
I was
donate.
an organ donor, but
Yeah. So there's different reasons to donate organs. So there's organ donation for transplantation, but there's also organ donation for science and research. So this is just allows you to document what you want to have happen. And then there's the last section, which is sort of just general provisions that you can document, and then this last section is signatures and witnessing of those advanced healthcare directives. So again, the rules about filling these out and what the forms look like are different in every state, and on our website we have a link to every state's forms for this information. There's also something now called POLST. In some states it's actually MOLST. So POLST stands for either physician's orders for life-sustaining treatment or practitioner's orders or medical orders, but ultimately the rules are different in every state, so this is the link for every state's information related to POLST. And it's an additional document specifically for your healthcare providers to document what your wishes are. It doesn't replace an advanced healthcare directive. It's in addition. But now there are also some other practical things to consider beyond just these documents. So you want to make sure that you're actually having conversations with the people that you care about. I've had people tell me, well, you know, my kids are not going to fight over anything. They know what my wishes are. It's not going to be a problem. And unfortunately, there are lots of examples where when emotions come into play, it makes things more complicated. And certainly when money comes into play, it also makes things more complicated. And so estate planning is really just about making sure that your wishes are documented, whatever those wishes might be. But it's also important to have conversations with your loved ones. So if you've appointed your sister as executor of your will, you probably should let her know that so that she's prepared, and to have a conversation just so that she makes sure exactly what you want to have happen happens, even if it's documented. Because sometimes family members want to understand the rationale behind some of those decisions, and it can help ease the process. We also now have all sorts of accounts that are online. So if you have an email account, or you have a social media account, or you have a music account with all of your music that's now online, there are actually processes for how to deal with those things. So on social media accounts, every platform has a different process. Some of those platforms will become memorial pages. Some of those platforms automatically end. Every platform has a different process, and so it's important that if those things are important to you, or if that's a way that you are getting support in the community or want to be able to continue to get support, for your family members and friends, that you decide how you want that to be handled. And then I think something that's really under-discussed is funeral planning. Funerals are incredibly expensive, and I don't think many people realize that until in a moment where you're having to make those decisions for family members. There are ways to plan funerals ahead of time, and it doesn't necessarily need a ceremony, but in terms of actually figuring out decisions that you want to be made and how to actually pay for it. So there is funeral insurance, there are pre-planning services. We've included some links, and this is also on our estate planning page on our website, all of these resources. And again, it's a very personal decision. So I prefer to be cremated. My husband didn't like that idea. So again, documenting your wishes is incredibly important, and I know I'm harping on that, but it really makes a huge difference, and it alleviates a lot of stress and anxiety for family members, where if you haven't laid out what you want, are having to guess what you want.
Where is the best place to document them, rather than just write it and put it in your desk or whatever?
Can you wait one more slide? So there are also some really fantastic resources that exist. My Wonderful Life is just one example of them, where you can actually create messages. So for example, if you do have minor children or family members where you want to be able to celebrate things like birthdays or graduations from high school or college, you can do that through this account, where the account will then send those messages to family members and friends. So, storing documents, to your question. It's going to depend a little bit on what the document is, but the key, and this is also why it's important to talk to family members and friends about your decisions, if you complete a will, an advance healthcare directive, and instructions, and you put it in a safe deposit box, and you're the only person that has a key to that safe deposit box, that's pretty useless. And you haven't told anyone that the safe deposit box exists, not really helpful. But it happens all the time, because people think that's a safe place to put those things. So, again, it depends on what the document is, but if you have a will, telling the person who you named to be executor of the will how to access it is key. Sometimes people say, oh, I just left it with my lawyer, and I gave the person the name of my lawyer. Well, things happen to your lawyer too, right? Their office might close. We are constantly faced with natural disasters where buildings burn down or blow away. So, I mean, those are real logistical problems, so making sure that whoever your executor is knows how to access the will if you don't want to give it to that person ahead of time. If you have passwords to accounts, so if you put it on your computer, but your computer is locked, also not helpful. So you want to just make sure that whoever needs to access that information knows how to do that at the right time. We've had some people say, well, oh, I've given all of those documents to my priest, so that my family members know that they need to go to my priest if something were to happen to me. There are all sorts of ways to create a plan for that, but the point is to create a plan and make sure that the person who needs that information in the future can get access to it. There are also some new online services, so you could put it on something as simple as a Google Drive, which is free, and give someone the password to the Google Drive, or there's more sophisticated services like Master Lockball. So this is just sort of a brief overview of some of those estate planning documents, and I'm going to take questions, but I do want to mention that on cancerfinances.org, we have a module on estate planning, which includes this information in more detail and links to all of these resources and some other things to think through. So cancerfinances.org has an estate planning module. We have the estate planning page on triagecancer.org. And then we also have a webinar on our website on estate planning documents as well. So if in the future, you don't want to think about it right now, but in the future you want to learn more information, that's recorded and available on our website. And then these are some of the resources that you might want to take a picture of now, but are also available on our website. The link to download state-specific advance directives is there. And then some people find this whole process overwhelming, because it easily can be when you start to think about all the potential things that could happen in the future. So someone created a document called 5 Wishes, which is like an advanced directive, but it helps guide you through some of those decision-making processes to help you fill out an advanced directive. So some people actually prefer that form. You just want to make sure that it's valid in your state as well. So generally speaking, when we're talking about estate planning, there are lots of different documents, and you have to find the documents that are going to be right for you and the things that you need to do to document your wishes. But you also want to make sure that once you've done a round of estate planning, that you make changes to it as you need to. So if there are new members of your family, or if you've bought a boat, or you've actually thought about this a little bit more and you've changed your mind about how you want some of these things to happen, to make those changes to your will, do not leave the old copies of your documents lying around. There are plenty of court cases, and in fact, Aretha Franklin is a good example of this, where there are multiple versions of estate planning documents that are hanging around and people are confused about which one rules. So if you've made changes, get rid of the older versions. And then certainly make sure that someone knows where your plan is located. And I think it's also very helpful to talk to your family members or friends or whoever is included in your estate plan so that they understand what your wishes are. So with that, I'm going to open it up for questions.
I don't think it's exactly a question, but I've dealt with a variety of people's estates and not cancer necessarily. And, you know, in the old days, you'd find out about a person because the mail came in. And, you know, I remember my sister died, you find out she had an insurance policy because the premium due, you know, 6 months later came in or something. But now, if you're doing everything online, that's really, really critical to make sure you write that down and have passwords to all of your assets on it.
Absolutely. And I think even so on Cancer Finances, we even have a section about how to find lost life insurance policies, because family members might think that there's a life insurance policy that existed, but they can't find any paperwork. So there's actually a process to actually see if there's a life insurance policy out there. But you certainly want to try to avoid that if you can. Any other questions?
Just a really dumb point, these things. A friend of mine died a few years ago, and his son had the presence of mind to unlock his phone before his father was taken on the house. But you can come fingerprint and then change the passcode so that they could access his phone. And there was like, he kept all those passwords in his phone, all his computer records and everything. So, you know, you can do it numerically, or you can do it with a thumb.
Yeah, although
Or
depending
just
on what
pass on the
version of the phone you have, there's no thumbprint
Because these are
anymore.
next to impossible.
It could be face recognition or it's just code. So if that's where you've chosen to save everything, someone should know your
And the override is a
code.
numeric code, but that means that I would do it to my family member or something so that they could know what the numeric code is.
Exactly. Yeah, and especially if you change your passwords all the time, making sure that whatever document you keep your passwords in is updated too. Is there a question?
How does face recognition work? Like if somebody dies?
So, yeah. Yeah, technology has created all sorts of problems for us. These are the ones we don't necessarily think through, but important to keep in mind.
If you have regular healthcare institutions that you receive your service, from which you receive your services, do they usually keep your advance directives as possible, or do you have to bring them with you every time you show up for something? I mean, what's
That's a
the
good question.
practice?
So it depends on the healthcare facility. So if it's a larger health system and and they have like electronic medical records, they will upload your advance directive. Sometimes every time you go into an emergency room or you go into the doctor's office, they hand you the advanced healthcare directive to fill out. And you can say, well, I've already got one on file, or if you want to make changes, you can do that. It depends on the system in terms of how they approach it. So that's why you have to make sure that you can proactively ask them to do that as well. And that doesn't just apply to advanced healthcare directives, it also applies to the PULSE or the MOLS forms, and also if you choose to have a do not resuscitate form. But I think also what's important about the documents where you're choosing to make decisions related to your healthcare ahead of time, or you're appointing a healthcare proxy, that you talk to your healthcare team about that as you're making those decisions. And ask questions like, what could potentially happen? What, based on the treatment that I'm receiving, are there particular things that are more likely to happen than not? So I think sometimes when we're talking about estate planning to a general audience, it's harder for people to think about what those options are. But if you have a serious medical condition where you're working with your healthcare team, they can be very helpful in helping you think through some of those decisions.
Are there fees for these services on your website?
Nothing on our website, everything on our website is free, but some of the services, like if you want to hire an attorney, you're going to have to pay the attorney. We don't represent anyone at Triage Cancer, we just provide information about the law and connect people to resources. The statutory forms you don't have to pay to fill out, and you can find them on our website. Sometimes I recommend that people, even if they're going to fill out a statutory form, just have an attorney review it to make sure that it's complete and you've thought through everything, or you would probably need to pay an attorney. But there are also low-cost and free legal services in every community across the country. So if, depending on your income level, you can actually get help to complete estate planning documents as well. There are also local bar associations that have projects, and some law schools have legal aid days where they provide students and attorneys who volunteer to complete things like estate planning documents.
We currently have a will and a trust, but we're possibly going to be moving sometime in the future to a different state. So when we move to the other state, we should have them look at it and make sure it's...
Theoretically, in the United States, we have something called full faith and credit, where if you completed something legally in one state, another state is supposed to recognize that. But if you've had a change in, like, for example, if you sell your home in one state and move to a new state, you want to make sure that you've changed it to update that information. And I always think it's better to be safe than sorry. If you've gone to the trouble of doing this process, to make sure that it's still going to be valid wherever you move to is worth it.
Is it true that only a certain number of states are what they call joint property states for married people?
Yes. So California, for example, is a community property state where if you don't document your wishes, your spouse is getting, well, maybe I shouldn't say it that way. I was thinking of every exception to the rule. So in California, in terms of marital property, it's a community property state where technically your spouse owns 50%. If you have purchased a home together where you have a right of survivorship on the home, so it's the way that the real estate property deed was created, that you actually don't include that in a will. Because if you were to pass away, it automatically passes to your spouse. So that's why it's important to understand how you own things, because that will determine whether or not it can go in the will or not. Because in that case, the house would be outside of the will. Yeah.
For those forms that we fill out ourselves, must they be notarized?
Depends on the state that you live in.
California.
It depends on the form. So there's a joke in our office that our answer to questions is typically it depends, because there are lots of factors that are going to determine how it answers. So in California, wills do need to be witnessed by two people.
Not necessarily notarized.
But not necessarily notarized.
What about healthcare directive?
That's a good question off the top of my head. And I don't want to answer it because I'm being recorded over here. I was trying to see if we put California specifically in here. So the rules for every form are on our website. It's on our chart of state laws.